here studying for our Civ Pro finals and whatever.
Mm-hmm.
All right. So we have pleadings, disclosure, and discovery. Then pre-adjudication. Management. Okay, yeah. So this how pleadings, discovery, pre-adjudication, which is pre-trial, and then right here is trial if they end up going to trial, and then appeals. So
That's the order it should be in, even though she went
with appeals first.
Yeah.
Yeah.
So I'm like,
yeah. So this is like the stages of civil procedure. So in here we have like the complaint, and then that's for the plaintiff, and then the motions and answers.
Defendant.
That's gonna be the defendant answering the complaints. And then under there, obviously, you know, you have like 12B6 and yada yada yada, all that other stuff. And then discovery, that's mostly pleadings, the different stuff. And then before pleadings, actually, okay, so this is gonna be before pleadings, is service of process. Because if the person waives the service, then they get 60 days. But if they don't waive, the defendant, then if they don't waive, they get 21 days to answer. So this is like the first stage. So under service of process, they send out the complaint, and they have to send out the complaint with the summons, right? So that's under service of process. So number one, they have to have, which is called process. This is called process, which is the complaint and summons. Okay, so the plaintiff figures out that, all right, I want to sue this person for something. So the first step they're gonna do is get together, this is process. So process is your complaint, a copy of your complaint, and summons, which is basically telling them that we're gonna bring you a suit. No, you have to. So, all right, so let me do it again. Service of process is, and this is learning for all of us, but you know. So basically it starts with service of process, which process is what is a copy of the complaint from the plaintiff and a summons telling the defendant that they're gonna be sued. Then once you have process, then two, you have to serve it. And that is the rule that we learned, that it can be served by anybody that's a non-party and over 18. So once the process is served, that's the complaint and stuff, they now have notice, the defendants now have notice that they're being sued. Then they have to respond by either a motion or answering the complaint. So a motion is like our 12B, 1, 2, 3, all the way to 7. And you know, our professor's favorite, 12B6, failure to fail a claim. So in the service area, the plaintiff is gonna send, once they serve process, a file that basically gives them, a form that gives them the opportunity to waive service before they get here. So if they waive service, then the court grants them 60 days to respond. If they don't waive service, then they only get 21 days to respond. So basically, it's the courts are just trying to, bring down costs and stuff like that, because I guess it's expensive to serve people using like a U.S. Marshal or whatever. So that's like first. Then after the service and stuff is done, then they get to respond by a motion or an answer. And then their answer, they have to either all right, let me just go to discovery. So I can talk about that. So in their answer, they have to admit, deny, or state that there's a lack of sufficient information for them to give an answer. So in disclosure, that's where they're gonna be asking by motions for, well, not motions, but you have initial disclosures, and then you have things that they can ask for by like motions. So under initial disclosure, they have to give up like the party's name, address. You don't have to record everything. Basically, you'll start with like service of process. That's where you want to send out the information to say, hey, I am someone that feel like I deserve relief for something that somebody has done to me, and I want to let that party know what's up. I'm going to take them to court, right? So you have that where you send out your summons and stuff like that to give notice, to let the party know that you're going to try to sue them. In pleading, that's where you state what they did to you. So that's like your complaint and stuff like that. And then the party gets to answer back and say, I affirm, I deny, or I can't really answer that question or whatever. If you waive them, the first part, the plaintiffs, if you waive the service of process, so the plaintiff doesn't have to use a U.S. Marshal or stuff like that to serve, then you get an extra days to answer in the pleading stages. And then once you get to discovery, that's basically your investigation part. So now you guys are investigating the two sides of the parties, the two sides of the case. And if it wasn't already dismissed. So it can be dismissed if the plaintiff didn't have a plausible claim. The defendant can respond with legal basis to say why their claim doesn't make sense, and then it can be dismissed. If it's not, then they move on to the investigation stage, where they start to depose witnesses, talk to different people to find information. And there's different tools that they can use to do that. But before you get to trial, the courts usually try to have the attorneys to like meet up and try to settle things. So they might do case management, where that's where you get your 26F conference, where the lawyers have to meet with each other and try to come to agreement on certain things from discovery. They can try to settle the case so they don't have to take it to court, or go to ADR, which is alternative dispute resolution, which is like sometimes mediations and all that good stuff. So the courts basically want them to figure it out on their own before they have to take it to trial, or get to that stage where a judge has to make an answer or a jury has to give a verdict. If they can't settle all of that and figure it all out in that pre-trial stage by dealing with each other, then they have the right to go to trial. And then depending on the case, it could be a bench trial with only a judge, or a jury trial with juries that are selected. And they have to go through the trial situation. One party's gonna either prevail, the other is gonna lose, and then the party that loses has a right to appeal, and then that's the appellate process, where you would take your case and the decision that you felt like was wrongly made at the trial level to the appellate court. Or they can choose to give an answer. Motions 12B, 12E, and 12F, because you can make motions to dismiss from 1 through 7, 12B 1 through 7, then 12E is definite statement for, so I'm gonna put this as motion to dismiss. Then, I think this is more definite statement.
Yeah, motion from a definite statement.
And then F is going to be motion to strike. And a motion to strike can be made by either the plaintiff or the defendant.
This literally makes it so much more like sensible because she was just all over the place.
Right. I had to do this my own self to follow a timeline. So, okay.
Cause she gonna try it on that test. I know she is.
Right. So, 12B, 12Bs, 12B, 12BF.
12B 7 squared. Or
Right.
Is that even 7? What is that? 12B to the 7th power.
To the 7th power.
Well, 7 squared to the 7th power.
1 through 7. That's why you're in law school, sis. Don't worry about it.
That's right.
All right. So that's your motions to dismiss. Then your more definite statement. Then motion to strike. And I think that's pretty much it.
If you can do this, I'm fine.
Girl, of course you can. We just completed day 1 of studying down. Finals time. So.
You look great.
Yeah, feeling good, feeling great.
Look at her. Semester.
Yeah, so day 1 of studying went well. Well, that man have no personality. He always have like the driest face. I don't even know why I said nothing to him. Right? But yeah, hopefully we'll remember to vlog, and as we progress with this stressful time of year, I'll get the footage for y'all's entertainment on YouTube. Right? Looking raggedy busted, but you know, putting in the work or whatever. So yeah, that's it for today's vlog. Don't forget to like, comment, and subscribe, and I'll see y'all in my next video.